We're trying to put the positive on, on people with disabilities who encounter barriers with disability discrimination. But the reality is, people with disability grow up with facing discrimination, and it probably will start in the education system, and then go into employment, and then, before you know it, impacts on your relationship, your housing, and so they are like sort of re-traumatised all time and time and again. So for the definition of disability, this is a list of conditions. What I've noticed lately is that people in employment are being diagnosed with ADHD more and more often. This also includes past, present and future impairment, and this can include cancer, HIV, AIDS, that sort of thing. So, again, that is a list of the different areas of daily living, but today I'm just going to focus on the employment. So, what is disability discrimination? So there are two arms to this, the direct and indirect disability discrimination. Under Section 5 of the Disability Discrimination Act, and of course the Equal Opportunities, to actually fail to make reasonable adjustments in a workplace, such as assistive technology on your computer, or a safe working environment for somebody who's autistic, it's the failure to make reasonable adjustments, and it will lead to a disability discrimination claim. With regard to indirect disability discrimination, this is where, under say Section 6 of the Disability Discrimination Act, the employer may design a policy or a procedure. It can be around recruitment, to say, for example, anybody that applies for a lawyer's job, which happened to me, they've got to have a WA driving licence. Well, actually, I can't drive, but that condition in the advertisement put me at a disadvantage, and so I pointed this out, and by then I had the interview, but I got a better offer. Yeah. So the thing to think is the reasonable adjustment, or you're treating somebody less favourable. So two lawyers going for a job at the top law firm. I'm more qualified in my area than say the other lawyer. I'm being treated less favourable. So of course, when they see the guy job, they automatically think, well, she's not going to be able to do the job. So that's being treated less favourable. The slides are up there. I'm asking you to make reasonable adjustments and read it for yourself. Okay? So I've mentioned less favourable. So what's less favourable, as I just said, is being treated differently but for somebody without a disability. So you may have two people in the workplace, or one person with a disability and several people who haven't got a disability, and it may be that everybody's got to get into the office at 9 o'clock or 8:30. A person with a disability in a wheelchair might need longer to get to the office, or may have to catch public transport. They're being treated less favourable because they're already setting that person up to fail. So they're not allowing the person with a disability to say, hey, can I come in at 9:30? I'll make the time up. They say no, you're being treated less favourable and you're failing to make the reasonable adjustment. don't know who's blind, me or him. So when you look at a lawyer, when you look at a claim for disability discrimination, and I did touch a little bit, you have what you call a comparison test. You are comparing the person with a disability to that of other people without a disability. Later on, I'll just highlight this in a well-known landmark case as we go along. I know there are a lot of slides, but a typical example you couldn't apply this test is where you have a disability provider. So a disability provider who might be NDIS registered, and somebody complained because the support worker is not making reasonable adjustment. You know, can you use the comparison test in this? No, you can't, because all their clients have got disabilities. But you could use it in, you know, an office space or a department of government department. So you're looking at what the hardship would be for the person with a disability, and you're comparing it to somebody who hadn't got the disability. Okay. So, on the next slide, that one. So then, with this slide, you might have somebody who had got a disability, and then they put a claim in and saying, well, you're not making reasonable adjustment for my disability. And I've had a couple of cases like this, whereby, for example, like a caseworker for an advocacy service. He wasn't meeting the expectation for the KPIs, didn't understand what the advocacy services were about, or how to do case management, and that is not a disability discrimination case. That is the person who doesn't have the skills to carry the job out. Okay. So this is a list of all relation to employment where disability discrimination is not allowed. So I mentioned one with the advertisement, condition that you've got to have a driver's license. I'll tell you a little story about me. I went for a job when I left the NDIS. I went for a position as a senior lawyer in a big city firm, and was successful, didn't disclose my disability, got shortlisted and got an interview. And I walked in, not the dog Joel, it was my first guide dog who I still got at home. Walked in with Ivy and sat down, and there was a panel of 3 males, and they all looked at each other and said, hi, yeah, I'm here for the interview, you know, blah-de-blah, and but there were more that, you know, told me to sit down and look through my CV. And I'm waiting for the interview, of course, I'm nervous, and one guy said, oh, how long have we had your guide dog? What's she called? I said, Ivy. Oh, I've had her 4 years. Oh, that's good, you know. And how long did it take to train them? Well, 2 years. Okay, yeah. And then another guy said, how are these, you know, how are they trained? Who paid? I was, well, you know, charity or the NDIS. And then I got really peeved, and the black guy said, isn't she beautiful? And I said, you know what? I'm not bad for my age, am I? And walked out. I never got the job, but I didn't want it. I got a better offer. So, anti-discrimination law. So, the anti-discrimination law, there is the Equal Opportunities Act 1984 and the Disability Discrimination Act 1992. You saw John Burns, who is the Equal Opportunities Commissioner, and Rosemary Kern, who is the Australian Human Rights Commission Commissioner. So these two acts govern the discrimination law. They are outdated, antiquated, and not worth really the paper written on them. These acts do not have any teeth, unlike that dog over there. Okay. So we've heard that under the Disability Discrimination Act that the employer has to make reasonable adjustment, and they've got to not treat a person less favourable but for their disability. You can start you can start the process by, if you're in an employment setting, you can put a formal complaint in. Start it with this. Don't go rushing to court. Well, you can't go rushing to court because you have to go through a process. So if you feel like you don't get anywhere with your letter of complaint, get the union involved. If you're a member of the union, use them. If all that failed, and they failed to make reasonable adjustment, and you've got medical evidence to say that you need reasonable adjustment, then the next step is to take a complaint to the Australian Human Rights Commission or the Equal Opportunities. Both of them have backlogs. You're looking at the Australian Human Rights Commission, you're looking at probably 8 months, and the Equal Op, you will get heard a bit earlier, but from a lawyer's point of view, I think the Australian Human Rights Commission is more robust, and its federal law is prevailed over any state. Okay.
Sorry, can you just repeat what you just said?
Yes, so you've got the Australian Human Rights Commission complaint, which governs the federal disability discrimination legislation, and then you've got the Equal Op that governs the state law. But I always find that the Disability Discrimination Act is more robust, and the conciliation process is better. But having said that, the Equal Opportunity Act is actually going under reform. It had been doing for 3 years, but it's sat on somebody's desk still waiting to get that in line. Okay. So, what can you do to improve the workplace? So, well, the employer can look at the policies and procedures, and you saw that in the video, and it's about the employer not being frightened to take somebody on with a disability. We have a lot to offer. One of the big factors is that attitude has got to change. We've moved from a medical model to the social model. The medical model is basically, well, you're the victim, you've got the disability, you're creating the barrier. Social model is, well, no, actually, I can't get up those steps, I'm in a wheelchair. You're creating the barrier, put a ramp in. I touched on the, you can skip this, I touched on the Australian Human Rights Commission and the Equal Op. This is the part that really troubles them. And this is the inherent part of employment. What does the inherent part of employment mean? Now, probably maybe 15, 20 years ago, you could have said, Or the employer could have said, well, she's not capable, or even a bit longer, 20, 25 years, she is not capable of being a receptionist because she's legally blind and she can't carry out her role as a receptionist. That is the inherent role or part of the job, is the very essence, the heart of the job role. But this is getting more and more difficult to prove because technology it evolved so much over the years that there's really no excuse for an employer to say, well, no, you can't do the inherent part of the job. You know, that's not acceptable anymore. So examples. So you might talk about communication skills, which I talked about, the receptionist, which is up there. You might have mobility issues that you're not able to get from one floor to an office to another one. These are all reasonable adjustments. One of the cases that I dealt with, and it was a chef, like second chef, he was in a road traffic accident and he sustained spinal injuries and he ended up being in a wheelchair. Now, of course, the chef's got to stand up, high bench there, and the employer said, well, he can't do the inherent part of the job. So I come along, caused havoc, normal. Well, no, actually, he can. You've just got to make the reasonable adjustment. Oh, no, the health and safety issues. No, I can't do the inherent part of the job. So it went to the Australian Human Rights Commission, and we took it to the complaint process. And, you know, I'd had this conversation with the employers, met with them and said, look, you can get in touch with Job Access. This is a government funding, and it will fund any equipment like technology or like the bench that a chef needed to work. And to cut a long story short, we got one paid for by Job Access and he was able to do his job.
Was that in the public or the private sector? Do you remember?
Mm-hmm.
Was that, because you gave a live example, was that in the public or the private sector?
It was the private sector.
It was the private sector.
Yeah.
We also have a question from Tara at the back.
Yeah.
Yeah, sorry, I just had a quick question. We get issues like this recently often in the retail industry, where people have had accidents or illnesses outside of the workplace, which has then limited their capacity to return to their jobs. We have one right at the moment where a woman suffered some burns, and she can do everything she needs to do, but only for limited periods of time. And the employer has now stood her down without pay until she can come back to do her full shifts. And, you know, in our mind, she has capacity, and the only adjustment that needs to be made is to allow her to do shorter shifts. But they say they can't reasonably accommodate that because of, you know, all of the other team members. The issue we have with it is that she doesn't have 8 months to sit in a queue at the AHRC. So I'm just wondering, like with your example here, sort of what the timeliness factor was for that particular person who obviously was, I mean, they obviously had a long recovery period, I imagine, from a car accident and so on. But how, you know, the wheels move slowly.
Yeah. Look, they have to make reasonable adjustments. So that could be shorter working days. It could be flexible working hours. It can be working from home for a couple of days. Yeah.
Is it worth just making an application to the AHRC to frighten the employer?
Yeah.
Because we know that it's not going to get hurt in a timely manner anyway. But
yeah. What's her disability?
She suffered some burns, which now prevent her from standing for long periods of time.
Yeah.
But it's a temporary disability as well, so it's not
well,
something that will.
Can I add?
Yeah. I mean, they do. You can look at temporary disabilities as well. Though somebody can have cancer and might need reasonable adjustment in the workplace where they get really tired and they're going through chemo, and so they reduce the working day, but then they could be cured of cancer later on. Sorry, I can only liberate one person at a time.
The general protections measures in the Fair Work Act will bring that they incorporate the disability discrimination legislation. So you can bring on a general protections claim that'll get you faster, a hearing faster than.
Yeah, you have 21 days to put Fair Work claim in.
But you can do it only if you're terminated. But the general protections you can pull these bits of legislation in and get them dealt with faster
While you're employed.
while you remain employed.
And
So
you
that
can
Yeah,
go for the
yeah.
injunctive relief.
And you can also put an Australian Human Rights Commission complaint in whilst you're employed as well. Whilst they have a backlog, if you can show that there is an urgency to the matter and that they are at risk of losing their job, then they will flag it up earlier. Yeah. So I had one, I was doing a conference this morning, and she lodged her complaint in July, and we managed to get it heard November. But she'd already missed the deadline. She walked out of and it was a government department, by the way. She walked out of her job, and mental health, psychological injuries, and missed the 21-day lodgement for the Fair Work. Okay.
Rita, can I ask a question about reasonable adjustments?
Yep.
And the example that you gave. So, to what extent is monetary cost considered a prohibition to reasonable adjustments? And if it is, does the employer have to consider or make, I don't know, reasonable inquiries into funding, like the example that you gave?
Yeah. So, look, let's talk about. So, for example, I mean, this is not really employment, but you can have a one-man cafe that's owned by one man, and he's got the upstairs and the downstairs. Person comes in a wheelchair and says, I want to go upstairs, but he can't get up there because there's no lift. He doesn't own the building. So what do you do? He will have a defence to the first person because, no, first of all, you've got to show that there's a hardship for the person with the disability. Well, is it going to cause them hardship to have a coffee downstairs? You know, if the owner's saying, well, look, you know, I'll ask one of the other customers to move upstairs, will you be happy then? But if the person said, well, no, I want to go upstairs, but then that person who owns the cafe can't afford to pay for a lift because he's only a small business. But if you have the likes of Coffee Club or Miss Maud, then they're a corporate chain of coffee shop or restaurant, then they couldn't apply that defence. The employer should make every reasonable step to see what funding they can get. Job access is really good. You know, if you need a workstation or like a desk that goes up and down, they'll fund it. There's also a programme called Work Assist, and normally not everybody, but the person with a disability can link into a DED provider, so that's the Disability Employment Port. And normally they will have officers going round and saying, you know, how's the job going, what can the employer do to help you. It is limited support, but they can also apply for job access on your behalf, or your employer can apply for it as well. Okay. I've lost my place now. So this one, this is Hollingdale, and I remember years ago that because I came from a nursing family, so you know, my sister's a nurse, we've got nurses in our family, and when I left school, I won't tell you how old I am, I wanted to be a nurse, but obviously because I had a hearing and sight impairment, they wouldn't accept me. These days, it shouldn't be a barrier. So in this case, there was a nurse who was deaf, and she argues that when the buzzer goes off in a hospital or aged care, she's not going to hear the alarm go off. She asked for a visual display where the light would flash, and the employer said no, you're not having that. It did go to court, and that was the outcome, and they had to get the reasonable adjustment put in place. Okay.
Yeah, Ryan?
Yep, Ryan. This one is again the Sunshine Coast Hospital. So this guy was legally blind, and he was trying to navigate himself around the hospital, but there was no braille or tactile on the floor for him to be, to find his way around the hospital. And this went to court, and the court ordered that the hospital had to implement these signage and all the reasonable adjustment for the tactile flooring. So when you go outside, you'll see these bumps. Just as you're walking up to like the traffic light, a person who's legally blind will feel those bumps, and they'll know they're coming to a traffic light or a road curb.
Cosmo?
Yeah, Cosmo, yeah. Yeah, okay. Yeah, so this is the government department, Department of Justice, and again, a person who's blind and failed to make the reasonable adjustment by applying a screen reader or the assistive technology. And again, it went to court, and that was the outcome of that one. That was the outcome of that one. What you've got to remember is, one of the worst offenders are government departments. I actually took a case on, and I can talk about it because it went to the media. So this person, I won't disclose her name, but before she lodged her Australian Human Rights Commission complaint, or in the Equal Ops, she went to the Australian Human Rights Commission complaint. She went to the media, and the ABC picked it up, and they put it on 60 Minutes. Anyway, if you have a look at it and look at NDIS employee discriminated against, it was about 2 years ago. And she lodged it at the Australian Human Rights Commission. The media had a field day because the NDIS is a service to provide people with disability funding. So this is the Maguire versus Sydney Olympics. And although this didn't actually affect him per se, the deaf-blind man, he wasn't able to access the website or any information given to him, and they were ordered to make it accessible. And this was the landmark case that deaf precedent across the country to say, hey, all websites have got to be accessible. this one, in fact, I actually did a similar one this morning to this. The WAT versus Australian Postal Corporation, 2014. And this involved a person who had mental health impairment, and because they failed to make the reasonable adjustment, it caused her to have a psychological injury. It was taken to court on the ground of disability discrimination, and if you go on to the next, this was the outcome. Now, bearing in mind, this was the outcome, so she got the leave. She only got it for 4 months, because then they put the reasonable adjustment in. But she got a leave reinstated, she got 10,000 injuries to feelings and some other stuff there. You can see on that overhead. But what it didn't stop her from doing is she could also put a workers' compensation claim, because the psychological injury was such that it impacted on her, and she was diagnosed with PTSD, and I didn't do the workers' compensation side of it, and she also got compensation for that. Section 11, I've covered that, where I talk about the unjustifiable hardship, and I covered the scenario where the one-man band cafe against, like, you know, big organisation like the Coffee Club. And there are, on the bottom of that slide, you've got to show that it's a hardship for the person, and then you've the last bit, which is the financial implication to the first person. So, if you were looking at the legislation around employment, you need to look at Section 15 of the Disability Discrimination Act and Section 66B, and that basically covers, so basically, you know, you can't be discriminated in employment, you can't be treated less favourable, whether it be the recruitment process or promotion or loss of status. So you might have somebody who is a team leader, and because of the workplace bullying or harassment, she developed a mental health impairment of depression. She can ask for reasonable adjustment. They fail to make the reasonable adjustment, then it's discrimination. If they say, right, okay, you're not capable of being a team leader anymore, and they downgrade her to a caseworker, then that's loss of status. A little bit on contract work, contracted, and that's self-explanatory. If you have a person who is a contractor, so they're going through a recruitment agency said, hey, we've got a job for you, you know, you can go and cover the receptionist at Harvey Norman, and they said, oh, well, no, actually, you're blind, we don't, you know, no, we can't, and she's a casual or a contractor from a recruitment agency, that's discrimination. Those vicarious being passed over, even though she may be employed by the recruitment agency, you can join the recruitment agency if they actually fail to say, well, no, actually, she's got a disability, you shouldn't be doing that, or if it's just they will, no. And then the person who, the company that's actually giving the role as a contractor, so you can join them into the complaint. It goes case by case. Just conscious of the time. I think what I'm going to do, because I'm just running out of time, if you just skip the study case, the 3 slides, I'm going to give you a summary of this. So this case involved 2014, and it was around sheltered workshops or ADEs. So
Sorry, is it 20, this case study 1?
yeah, but the flag 3, yeah. But it's a bit long-winded and legally mind-boggling, so I'm just going to put it in a summary. So in this case, what happened is it was for around people with disabilities who were employed in sheltered workshops or supported workshops, and they were receiving probably $1 an hour. And these guys and girls were doing like making pallets, preparing flight bags for, you know, the flight, all sorts of, you know, good stuff. And so what happened is it was actually challenged because it was governed around a tool. So how it was set by the government and how it works is that, well, if this person's got an intellectual disability, the low level, and so they should only get $1 an hour. But in actual fact, this happened to somebody who was cerebral palsy, and then another one, Purvis, who was legally blind. They were both reduced from their hourly rate to something like $1. This was challenged. It went all the way to the Australian Human Rights Commission, went through the rigmarole of the Federal Circuit Court, then went, and it lost the case. Then it went to High Court, and basically the judge said in that, well, basically they can't do the inherent role of the job. Anyway, so it was appealed again, and they won the case. So the tool was redeveloped, and they managed to get an increase in their hourly rate. Go past the study. Go to the part where there's like, you know, the data from Equinox and the Australian Human Rights Commission. Yeah. So in 2018, on that slide, it's up there. There was X amount of cases lodged in Equal Opportunities, and also the Australian Human Rights Commission complaint. What I'm going to do, I'm just going to read this because I didn't have time to put this in the slide. Okay, so Australia ranks amongst the OECD countries, which is a big governing about economic around employment. The OECD countries in employment rate for people with disabilities. Recent data place is around us, Australia, 21st out of 29 out of 29 OECD nations. This is really reflecting significant challenges in employment inclusion for this group. Compare that to other developed countries. Australia employment rate for people with disabilities remain below the OECD average, highlighting gap in accessibility, accessible workplace support, and also social attitude towards people with disabilities. This low ranking suggests substantial room for improvement, especially in making workplace more accommodating and addressing the discrimination. Furthermore, Australian youth of Australian Disability Enterprise, which are the ADEs, I talked about the hourly rate, for supported employment, had been flagged and criticised for paying the lowest wage to people with intellectual disabilities, which international standards suggest may contravene the right to equitable employment. To address these issues, the OECD had recommended that Australia includes shifting towards more inclusive open employment and comprehensive national countries such as Sweden and Switzerland, who are the leading countries to make the employment workplace accessible for all people with disabilities. There's only, we as a society, we as a country, we are all equal citizens in this country. Myself and all those in my disability community deserve to have a fulfilling life, have a job, have a meaningful relationship with a partner, have accessible housing, be able to have a mortgage, and so forth. But it's not happening. It's not happening. So the first thing that we have to do, and this is why I'm actually on the advisory council for the federal and the WA government, to address those systemic issues. Not going to happen overnight, but we all work together to make it a better place for people with disabilities, then there will be improvement. I always finish off with one of the quotes, who, well, she was an American and she's deaf-blind, totally deaf, and there was a movie made about her and it was called The Miracle. She actually went on to say, alone we can achieve nothing. Together we can achieve so much more. And that's it in a nutshell. Please, if you have any client that you're representing in a union capacity, refer them to a community law centre. We offer a free service at Sussex Street. We are the only statewide service, including Circle Green, they do cover employment, that can offer free legal advice and representation. And that's me in a nutshell. Thank you.